Hi, good afternoon, everybody. My name is Romy. I'm an attorney here in Miami, Florida. I practice different areas of law. I do real estate law, probate together with my firm. We do immigration, litigation, copyrights, business law. See, what else am I missing? Trademarks and some litigation. Today's class, we're going to focus on probate, and a lot of things come into play with probate. We deal with real estate, we do a little bit of probate. Sometimes it can become a little litigious. So I want to make representation as interactive as possible so everybody can benefit from it. Please feel free to place any and all your questions on either the Q&A or the chat, and I'll answer them as I go. Thank you so much. I'm going to proceed to share my screen now. Give me just 1 second. Okay, perfect. So probate for realtors, that's today's class. I'm going to be presenting the other probate attorney in my firm. Her name is Diana Collazos, but she's not presenting today. It's just me. You will see a couple of cats because I do like them, and doggies too. I'm very animal friendly. So first, let's start with the basic. What is probate? Well, probate is a court supervised process for a couple of things. It's to establish the validity of a will, because yes, wills can be invalid, and we'll discuss what makes a will invalid. Is to identify and gather the assets of a deceased person. In this case, we'll refer to the deceased person as the decedent. It's also to pay, the decedent's debt. Just because you go to heaven doesn't mean your debts go away. Those are things that need to be addressed as well through the probate process. Lastly, probate is used to wind down the decedent's financial affairs and then distribute the decedent's assets to his or her beneficiaries. So essentially, that's what probate is. All the assets, let's pretend they go into a little box. It's the state, right? And then we determine whether the will is valid. If the will is invalid or if there's no will, there is a specific process of how to go about probate. Then we gather the assets of the deceased person. Now, don't think that there's a record that we can go search and see, okay, this person owned everything. If the family members don't know, if the attorney doesn't know, if the CPA doesn't know, there might be assets that we don't know that existed, and they will not go through the probate process, and the beneficiaries will not benefit from it because we don't know of its existence. That's what is so important to let our family members know. I have this bank account, or have a list or something, a folder with all your assets, so that in the case you need a probate, they know exactly where to go and get them. Lastly, we're going to talk about why some debts do need to be paid from the decedent state and some don't. Some are exempt, and we'll discuss that in a minute. So I told you that basically when we have a probate, what happens is all of the assets go into this box, right? But not all of the assets owned by the decedent go into this box. There's basically some assets that are exempt from probate and do not go to the probate process. And in fact, they may go to the person that's going to benefit from it, the heir, directly. And we will discuss that in a minute. So probate administration applies only to probate assets. Probate assets are those assets owned in the decedent's sole name at death or owned by the decedent and one or more co-owners and lack some type of provision for automatic succession of ownership at death. Examples of assets or property that may be a probate asset may include a bank account or investment account in the sole name of a decedent is a probate asset. However, a bank account or investment account owned by the decedent and payable upon death or transferable on death to another person or held jointly with rights of survivorship with another person may not be a probate asset. So that's the first thing, and that's the most important thing that I like to tell my clients and people that I meet regarding probate and bank accounts. We encounter situations where there might be $5,000 in the bank account, and now we have to do a whole probate process because the person never designated a beneficiary. It is very simple for all of us to go right now to our bank and talk to our banker and say, in the case something happens to me, I want this account to be payable upon death to X, Y, and Z. Could be your kids, could be your sister, whoever you want. And that way, that asset, that bank account will not have to go through probate. That person will have access to it upon your death. Now, you could also add them to the account right now so that you have joint ownership, but I understand that some people don't want to do that for whatever reason. So you can just make the account, the investment account or the bank account, payable upon death. However, you want to receive proof that it was done, because we had situations where we have people come to our office and they tell us, well, my father told me that this account was payable upon death to me. And we ask them for proof. Well, show me the paper that it says that it's payable upon death to you so we can tell the bank, and they don't have anything. So if you do decide to make your bank account or your investment account payable upon death, it is very important that you receive proof from the bank that it was done and that you provide it to whoever is payable upon death to. If you have joint bank accounts, so if you and your spouse have a bank account, you and your friend have a bank account, then what's supposed to happen is that upon your death, the other person owns the whole bank account, okay? But you want to make sure that's how it's set with the bank and that there's an understanding that that's what's going to happen. Life insurance policies, for example, annuity contracts or individual retirement accounts such as 401k are a probate asset if they're payable to the decedent state, right? But if you decide that you want to name a beneficiary of your 401k, of your annuity contract, of your insurance policy, then they're not supposed to be a probate asset. They're supposed to go directly to the beneficiary. But you have to name a beneficiary, because if you don't, right, then it will benefit your estate and it would become a probate asset. Real estate, and we deal with real estate a lot. Real estate title in the name of the decedent. So if it's only title in the name of the decedent, then it will be a probate asset. Or if it's title in the name of the decedent together with somebody else as tenants in common, then it will be a probate asset. So either the whole property will go through probate, or that portion that is owned by the person that passed away will have to go to probate. However, in Florida, you can fix this, right? If you don't want it to be a probate asset, you can have a property that is by joint tenants with rights of survivorship. If you have property that's named as joint tenants with rights of survivorship, that means that whoever survives the other will own the whole property. It will not have to go to probate, and it will not benefit your heirs either. Also, you can do something called live state. So a live state, and maybe you've heard it under Lady Bird deed and other names like that, basically means that you can have property title in your name, that you have the possessory interest, so you have the right to live on it during the time that you're alive. But as soon as you pass away, it goes to the remainderment, or to whoever you designated as the remainderment. That we do that too. It's called a live state. And we can do that so that way it won't go through probate. The remainderment, or the person that's going to stay with the property, all they have to do is basically record the death certificate, and now they are the owner. Now you can do an enhanced life state where you could actually say and limit the powers of whoever is going to do, whoever the remainderment is, or whoever the life tenant is. You can limit the powers that they have. You can limit it, and by that I mean they will not be able to sell the property. They will not be able to mortgage the property while they're alive, if you put specific limits within the deed. But if you don't put those limits, and you can say that the life tenant can do whatever with the property, they can sell it, and then the remainderment will not get the property. But going back to avoiding probate or not, if you have a deed that is title or prepared in a way that is a life tenancy for one person, and then it goes to remainderment, that will not go through probate. Another type of deed that will not go through probate is property owned by husband and wife, entitled as such. So for example, we can have something that says Peter and Maria as husband and wife, or something that says that it doesn't necessarily mention husband and wife, but they say tenancy by the entirety. Tenancy by the entireties is a protection that we have in Florida, only available to married couples, where basically each of the person in the marriage owns 100% of the property at the same time. So what does that mean? That if the person were to pass away, the property will not go through probate, because it's automatically owned 100% by the person that survived, the other spouse. All they need to do is record a death certificate, and that's it. But be careful, because we've had situations where, surviving spouses come in, they bring us the deed and they tell us, well, this is my homestead property. I own it with my husband, but only his name was on the deed. He bought this before we were married, but I understood because we were married, I would get it 100% and I don't need to go through probate. That is not the case. It avoids probate only if it's title in both names as husband and wife or tenancy by the entireties. If the husband or the wife bought the property before they were married, then they need to do a transfer of title. So they need to transfer it from themselves to themselves and their spouse. So that way it has that tenancy by the entireties protection and it doesn't go through probate. So to summarize, what things won't go to probate? Accounts, investment accounts, bank accounts that have either a joint owner or that have language which makes it payable upon death. That will not go through probate. Life insurance policies, annuity contracts, or individual retirement accounts, as long as they have a designated beneficiary. And then real estate titled as joint tenants with rights of survivorship will not go through probate. Real estate titled as husband and wife or tenancy by the entirety and one of them dies will not go through probate. Or real estate title using the way of life tenancy with remainderment or ladybird deed, that will not go through probate either. So if you have any of those avoid probate. So when is probate necessary? And again, you can place any of your questions in the chat or Q&A. Probate may be necessary to transfer ownership of the decedent's probate assets to the decedent's beneficiary. If the decedent left a valid will, the court will admit the will according to the procedures to transfer the ownership of probate assets to the named beneficiaries. If the decedent had no will, probate might be necessary to pass ownership of the decedent's probate assets to those receiving them under Florida law. Some assets do not require a probate proceeding to transfer ownership. Probate may also be necessary to wind up the decedent's financial affairs, and administration of the decedent's state ensures that the decedent's creditors are paid off if certain procedures are correctly followed. That is correct. Probate is not just to pass the assets to the heirs. The creditors want to be paid too. So what happens in real estate, right? So what is probate real estate? Well, it's usually the same, whether it's an heir, seller, or buyer. The definition of probate real estate never really changes. Someone owned real estate, they died. And in order for the rightful heirs to have title to the real estate, in order to sell, convey, transfer, the heirs have to go through this formal court process called probate to officially transfer title. So I deal a lot with realtors where they come to me and the title company basically is telling them we cannot close because this needs to go to probate. My advice is from the beginning that you get a listing, try to find out who the owners are. Of course, you need to know that. But if they mention to you, oh, it was my aunt and she passed away, or my aunt owned it through an LLC and she passed away, you already need to be thinking about probate. Try to get them all to sign the listing agreement, because if all of the heirs don't sign or the personal representative signs, and I'll explain to you what a personal representative is, they can use that to try to get away from the listing agreement. So try to get all of them to sign, try to make them, or not make them, but try to get them to start working with a probate attorney as soon as possible, because depending on the case, probate can take a little bit. If it's homestead property, it might be faster, but if it's not, it's going to take a while. And of course, whenever you put your listings on the MLS, make sure that you correctly display that it's subject to probate court approval, because it will be. And the courts, depending on which court it is and what time of the year it is, they may take a little bit or they may not. So we want to make sure that all of your MLS, because you don't want to misrepresent, your MLS listings show that it's subject to court approval, that if you do enter into a purchase agreement, and this is extremely important, you also specify that it's subject to probate court approval, because it will be. And that you get the heirs and whoever are the beneficiaries to start working with a probate attorney as soon as possible in order not to, delay the process. Now, we do probate all over the state of Florida, even though we're based in Miami. So regardless of where it is, we can help you, do the probate and resolve it hopefully quickly and efficiently, unless it becomes litigious. So why should realtors care? Well, one, we want to avoid wasting time. We don't want to waste your time. Also, you might be dealing with the wrong person. Sometimes people tell you, yes, my property, I'm going to be the one inheriting, and they're not. Also, unless you're dealing with an individual who has appointed personal representative by the court, you need to ensure that the rightful heirs are on board with the sale to avoid delays. So if the probate process has not started and there's no personal representative appointed, get all of the heirs to sign. Otherwise, I'm telling you, because I've seen it, one of them is going to say, no, I don't want to sell, or no, I want to buy it for myself. And they're going to try to say that your listing agreement was null and void because the person that signed it didn't have authority to sign. And now what you have done is just simply waste your time. Let's see, I think we have a little question. What time frame do probate court approval take? 30, 60, 90 days? That's a great question. So if the probate is open, we have been able to obtain probate court approval in 2 days. So what takes time could be not the court approval, but opening up the probate, setting up, filing all the documents, whether it's the will, if there's no will, whoever the beneficiaries are, appointing a personal representative, that can take a little bit of time. Once the case is open, we submit the contract, we submit the CMA report, the market comparative analysis report. We submit that and we tell the judge, please approve this. And they're fairly quickly. So what takes time is not that itself, it's having all the probate process open. That's why I tell all my realtors, please, if you think there is even an if of probate, have them contact us. And then great advice for you, great tips or I guess, news for you guys. We do free probate consultations. So even if you're not sure if there's a probate, just get them to contact us. We'll discuss with them and go from there. A lot of people have the misconception that because they have a will, they don't need to go to probate. That's not the case. A will still needs to be probated. So have them speak to us and we can answer their questions. Also, as I told you before, you want to make sure that the contract states that it's subject to probate court approval. Because even though I'm telling you it could be fairly quickly, we never know, it could take longer or whatever could happen, or maybe the heirs start fighting and now they don't want to sell. So you want to make it subject to probate court approval. We have two types, I want to say, of probate states. We have testate and intestate. So testate succession is when the decedent has a valid will, okay? Because we've seen wills, we're actually litigating one right now where they're invalid. But if assuming the decedent has a valid will, then the court, the probate court, the role is basically just distribute the property according to the decedent's instruction in the will. They appoint the personal representative as indicated in the will, and then that's it. And then they find out that we need to find out if the decedent left the will because it requires the custodian, whoever has the original will, to deposit it within the probate court within 10 days, right? In the will, you can nominate guardians for minor children. You can also disinherit people. And I do quite a lot of disinheritance because I guess kids become rowdy sometimes. If you want to disinherit anybody and they're a direct heir, I want to be as specific as possible. I want to name the person, their maiden name, their legal name, their date of birth, where we think they reside. I even want to put there the reason why we're disinheriting them. So that way there's no question at all that you meant to disinherit that particular person. Is a living trust the best way to avoid probate? Okay, so we were going to talk about living trusts and how that does avoid probate. And it is the best way to avoid probate combined with other stuff. So we're going to talk about that in a minute. Yes. We also have intestate succession. So this happens when there is either no valid will or there is no will at all. Here's a little chart to see who gets what. We find out did the decedent have a wife? If not, did the decedent have children? If not, how about parents? No parents, uncles, aunts, cousins. If nothing at all, then it goes to the state. But this is like an analysis that we do. We have encountered people who really have no family, and we prepare their will and their situation of what they want to happen to their assets. And a lot of them want to donate it to charity. And it's important if you have no family, to do your estate planning, because people will come out of the woodwork to say that they were an heir of you somehow, somewhere, one way or the other. I'll tell you guys a specific example that I had that actually made me really happy, not because the person passed away, but because her legacy was able to live forward. So we had a client who had no heirs at all. She lived extremely frugal, super frugal, but she had managed to accumulate wealth around 700,000. No, I would say 800,000 between cash over 500,000 and the apartment that was worth, 200,000-300,000. And her wish, she was very specific, was for it to go to this particular university to benefit kids who were disadvantaged economically. And that's what she wanted to happen. And then that's what we did. We prepared a will, we communicated with the school, we told them what this person wanted. They would talk to her every so often. And then she passed away. I think 4 years passed and then she passed away. She had prepared everything, her funeral expenses, everything. People came out of the woodwork to come to me. telling me that they were the ones that received the money, that she owed them this money, that she owed them that money. They wanted to make claims. Thank God nothing happened, because we were able to prepare for all those things. And the money did go to establish a scholarship on her name to benefit, this people or kids, that are disadvantaged economically. And that is what she wanted. So there's a lot of elder abuse, sadly. People get them to sign all sorts of things. But because we were able to do her will, continue with communication, get the university involved with the communication, whoever was trying to say that they did something else to change her will was not deemed valid. So we didn't have an issue. And the money went where she wanted it to go. All right, let me talk about two types of different administrations, summary and formal administration. So summary administration is the most simple form of administration. It does not require the appointment of a personal representative. It can be completed when the decedent has been dead for more than 2 years and the will does not direct for formal administration. It can also be completed when the value of the entire state subject to administration in Florida is less than $75,000. And important, homestead property is exempt as a result, so it doesn't count towards the $75,000 limit. So we have cases, for example, where the person that died has a property that's $600,000, but in the bank, they only have $25,000. Only that $25,000 will count towards the summary administration limit, so we're able to do summary administration fairly quickly. Formal administration, this requires more work. It's usually needed when the assets of the decedent are in excess of $75,000, or the decedent has been dead for less than 2 years, or for some reason or another, you want to get a personal representative appointed by the judge. For example, let's say you want to sell real estate during the probate process, or more likely than not, I get people that, for example, they know that the person had a 401k. They didn't know where, they didn't know how, but they thought or they think that they were somehow beneficiaries of the 401k. So then the bank will, or the people that hold the 401k, the investment accounts, will not talk to them. They will only talk to the personal representative. So then we do a formal administration to get the personal representative involved. Same thing with the banks. Let's say the person that died had a couple of different bank accounts. The bank will not speak with you. They will not. They don't care if you're the mom, sister, daughter, lover, whoever, unless you're appointed personal representative. So that is some reasons why we would have to appoint a personal representative so that they find out how much there was in the bank. Formal administration is also recommended when you have multiple creditors, when you need to provide formal notice, or when the borrower is deceased and the bank does not want to provide information without a personal representative, which sadly we see a lot. So please, if there's anything you learn from this class today, is if you have accounts that are solely in your name, go to the bank and designate a beneficiary so that if something happens to you, they can simply go and get the money without asking for anything. They can just go and get the money because now you passed away, they record your death certificate and that's it. I hate it when we have to open up probates for $4,000 in the bank, $5,000 in the bank, because then what do they really get? They have to wait all that time to go through all of that. And then the creditors can claim an interest on it. We don't want that. So if there's anything that you get from this class is to go to the bank to designate who you want to receive your money in case something happens to you. I mentioned that we go through probate and we have either intested or tested, and the difference is whether there is a will. Well, sometimes we have wills that are invalid, right? So we have wills that were executed. I'm Peruvian, so sometimes we have wills that were executed in Peru, not according to Florida law. Sometimes we have some fraudulent wills. So what is required for a will to be valid? Well, for a will to be valid, it must be in writing, okay, very important. It must be signed by the decedent and witnesses and comply with the execution requirements for Florida law. In the will, the decedent can name the beneficiaries whom the decedent wants to receive the decedent's probate assets, and also the decedent can designate a personal representative. That is Florida's term for executor to administer the probate state. So in Florida, the requirements for a will to be valid is that whoever makes it has to be of sound mind and 18 years old or older, or an emancipated minor. We get calls a lot of times by people that tell us, Romy, my dad is extremely ill in the hospital. He's gonna die really soon. We need to do his will. He's not thinking correctly anymore. Red flag, I can't do your will if you're not thinking correctly anymore. It's too late. Or they tell me, Romy, my dad has dementia, or my mom has dementia, and we really need to do a will. They never worried about estate planning, and we really want to make sure that everything is provided for. Nope. Or Romy, my dad is dying of cancer. He's in really hard drugs. He can't be without drugs, and he's just not thinking well, and he's not lucid, and we need to do his will ASAP. Either. Can't do any of those, because if you're not of sound mind, that will is invalid. So it's so important to do it now when we are of sound mind. So there's no question when the will is executed, was the person of sound mind or not. Also, the will must be signed by the testator, that's the person making the will, at the end of the document. If the testator is unable to sign the document, some other person may subscribe the testator's name at the end of the document in the testator's presence and by the testator's direction. Sometimes we get will from other countries that are signed on top, on the side, in the middle. That's not going to be valid. It has to be at the end of the document. Also, the will must be witnessed by at least 2 attesting witnesses who must sign the will in the presence of the testator and in the presence of each other, all together. And I recommend that the witnesses are uninterested parties, meaning people that are not receiving anything under the will, because we don't want to have issues where they say, no, you were not really a witness. You're saying that because you're receiving money under the will. We don't want to have any of those allegations. So it's better to have uninterested parties serve as the witnesses. Homestead property. If the owner of a property has a home in Florida that is his or her primary residence, Florida homestead law must be considered, okay? So the Constitution provides certain protections. If you have homestead property, you could only give it to your spouse or your minor children. That's it. You cannot devise or give your homestead property away to other third parties. Only your spouse and your minor children. Some exceptions. It may be devised to the spouse if there's no minor children, okay? A surviving spouse can waive homestead rights in writing with a valid prenuptial agreement or postnuptial agreement, but that agreement has to be so clear and so explicit, okay? So if you have a surviving spouse that's gonna waive their homestead rights or that's your agreement, make sure that your prenuptial agreement or your postnuptial agreement is extremely explicit. Otherwise, they can use this to fight off and claim homestead protection. If for some reason you try to devise your property, right, and not follow the homestead laws, then the Florida Homestead Constitution is going to come in and protect. So what happens with homestead property? The surviving spouse takes a life estate on the homestead property with a vested remainder to the decedents of the person that passed away per stirpes. That's the way that things go, that pass on in Florida. It's called per stirpes. So if somebody comes in and tells me, Romy, my husband died, the property was only in his name, what do I get? And there is minor children. Well, the spouse will get a life estate, meaning they get to occupy the property during their lifetime. But as soon as they pass away, it goes to the decedent's descendants. It's called a remainder. Or the surviving spouse may elect to take half of the homestead property as tenants in common, so they take half ownership, with the remaining undivided 1/2 interest in the homestead vesting on the decedent's descendants per stirpes. So let's say that the surviving spouse has minor children that are not the person that died children. They will still be protected. The surviving spouse can choose to only get half of the property. Of course, the property cannot be divided. So her name will just be untitled. And then the rest will be given to the descendants per stirpes, meaning in their proportionate share according to Florida law. Sometimes we have a person that makes a will and then gets married. So if that's the case, right? So when a person makes a will and marries after the making of the will, the surviving spouse generally gets what she would have gotten if the decedent died intestate, unless there is a prenuptial or postnuptial agreement addressing the issue, unless the will provides for the spouse, or the will clearly discloses that it does not intend to make a provision for the spouse, or the surviving spouse requests an elective share. So if you get married, my advice is please revise your will to reflect what you want to happen with your new spouse. Otherwise, the surviving spouse can claim what they would have gotten had there been no will. So it's so important to review our estate planning documents before getting married, after getting married, when we're thinking of getting married. If you really don't want to leave anything to surviving spouse, you want to have a good prenuptial agreement, good postnuptial agreement, so that everything is addressed. So what if a person dies without a will or legal heirs, right? So what happens in the case, for example, of my client that I told you that she really had no will and no legal heirs? Well, pursuant to Florida Statute 732.107, property reverts back to the state of Florida as a last resort, okay? So the property is sold and the proceeds are paid to the chief financial officer of the state. The cheated funds are retained as part of the state school fund. And after 10 years, the state rights to the proceeds become absolute. If your desire is for your assets not to go to the state, then you can choose to have a benefit at charity if you have no, survivors, or if you want to disinherit them. You can choose any charity. You can do your estate planning documents and nobody will find out until after you are gone. All right, so we talked about the personal representative, and I want to explain a little bit of who this is and also tell you that they can receive compensation for their work. So the person appointed by the court to oversee the administration or probate of the decedent state who must comply with the following: notifying all heirs and other interested parties that the will is being submitted to probate, identifying and taking control of any state assets, filing tax returns and paying taxes, paying creditors' claims, managing any assets such as investments or real estate while the will is being administered, selling assets to satisfy claims against the state, filling out all necessary documents and other paperwork with the court, distributing the assets to the heirs, and then preparing and submitting a final accounting to the court. All of those things is what basically a personal representative does, and they can receive compensation. Usually it's going to be around 3% of the value of the state. So who gets appointed a personal representative? Under Florida Statute 733.301, the following is a preferred order in appointing a personal representative. In testate states, meaning states where we have a valid will, the personal representative or his or her successor nominated by the will. Also, the person elected by the majority in interest of the beneficiaries. One of the beneficiaries, if there are many, the court can select one that they deem to be most qualified. That's the order if we have a will. In intestate states, we have a different order of who gets appointed personal representative. We have the surviving spouse. Also, it could be the person elected by the majority in interest of the heirs. Or lastly, the heir nearest in degree, if there are many, the court selects the one they deem to be most qualified. Important, under Florida Statute 733.302, any person who is sui juris and a resident of Florida at the time of death of the person whose state is to be administered is qualified to act as personal representative. However, if we have a convicted felon, they cannot be a personal representative. Somebody convicted of abuse, neglect, or exploitation of an elderly person or a disabled adult in any jurisdiction cannot be a personal representative. Somebody who is mentally or physically unable to perform the duties of a personal representative, they cannot be a personal representative. And somebody who is under the age of 18 also cannot serve as the personal representative. So I mentioned you have to be a Florida resident, right? We have a lot of foreigners that may buy Florida property and they don't know that even though they're a foreigner, as long as they have Florida property in their name, that Florida property, it's gonna have to go through probate. Or if they have Florida property owned by an LLC, that interest in the LLC, the membership interest in the LLC is gonna have to go through probate. So in all those instances, they may not have a person in Florida to serve as personal representative, while there are situations where a non-resident can serve. So under Florida Statute 733.304, a non-resident of the state of Florida may qualify as a personal representative if the person is a legally adopted child or adopted parent of the decedent, related by lineal consanguinity to the decedent, a spouse or a brother, sister, uncle, aunt, nephew, or niece of the decedent, or someone related by lineal consanguinity to any such persons. And lastly, the spouse of a person otherwise qualified under this section. So any of those people can serve as a personal representative, even though they're foreigners, they're not required to reside in the state of Florida. Now I want to touch again on how to avoid probate. Somebody mentioned a trust. So a trust is really the only document that allows you to control your assets while you're no longer here. You can be as specific in the trust as you want. You can say, I want this apartment to be rented for a period of 10 years, and then I want it to be given to my son or daughter because they're going to be this age. Or you can say, I want the assets in this trust to never leave the trust, and the beneficiaries will only receive the benefit, the income from the trust, but they cannot touch the actual assets. You can say that. I recently had a situation where somebody provided for their ex-nanny, for their ex-driver. You can do that too. You can say, for the life of this person, I want them to receive $10,000 a month, and when they pass away, that's it, it ends. You can, then the trust or the asset that they were receiving the money from reverts back to whoever you want, to your other children or to whoever you want. You can be as specific as possible. I have clients that have written in their trust document that they want their spouse to receive a certain amount of money monthly, but they don't want the spouse for any such reason to be able to sell the assets of the trust, because if they were to sell the assets of the trust, they would use it for gambling and then essentially leaving themselves homeless. So you can be as specific as you want. I have other ones that they wanted to say, my son should receive the benefit of this trust, but if he gets married, that benefit should stop unless he drafts a good prenuptial agreement with this and this clause in it. You can be, again, as specific as you want. And yes, assets correctly placed in a trust avoid probate. If they're not correctly placed in a trust, then they don't avoid probate. For example, we had people come to our office and they bring me the beautiful trust document, 50, 60 pages. I'm like, nice. And then they bring me the deed, or they tell me where the property is. And I look at the deed and it's named in the name of an LLC, or it's named in their own name, or his name. And I'm like, okay, when was this transferred to the trust? It's not enough to just create a trust document. You actually have to transfer the assets. You have to fund the trust. Otherwise, those assets are outside of the trust and they're still going to go through a probate proceeding. So what assets do really avoid probate? Tenancy by the entirety. And again, that is when husband and wife purchase real estate as a married couple and one of them survives. If they bought it before they were married, then they need to transfer it to the spouse and the new spouse together, husband and wife, to really avoid probate. Real estate title as joint tenants, but that's not enough, with rights of survivorship avoids probate. That means that if I own property with my friend and one of us dies, it will go to her, him automatically upon my death by recording the death certificate, as long as it's title as joint tenants with rights of survivorship. Also, life state deeds, right? So upon the death of the life tenant, the remainder man becomes the owner. All they need to do is record the death certificate, but it has to be a life state deed or ladybird deed correctly done, transferring the property, naming the property correctly, right? All those things have to be done correctly, and then it works. Trusts, yes, the trustee has the right to transfer property. It avoids probate. Again, you have to fund the trust. It's not enough that we form a trust. We have to fund it. Otherwise, it doesn't count. Anything really that has designated beneficiaries will avoid probate. For example, a bank account that you say, upon my death, it goes to this and this person. Life insurance, again, if you designate a beneficiary. Annuity contracts, retirement accounts, all of those should go to your whoever you designated to benefit from them without actually having to go to probate. But it's so extremely important that you actually designate the beneficiaries. A little caveat about designating beneficiaries that are minor. The problem with designating beneficiaries that are minor is that while you would say it avoids probate, now you have to go and open up a guardianship proceeding because they're minors and they're not able to make decisions of their own money. So my advice is, do not designate minors as beneficiaries if your plan is to avoid probate, because now you have to open up a well, not you, your heirs will have to open up a guardianship proceeding. So my advice is, find somebody that you trust and designate them as a beneficiary, somebody that you think will take care of your children. For example, in my case, I trust my mother-in-law with my life, and I know that no matter what happens, she will take care of my two daughters. So I named her as designated beneficiary of my retirement account, my life insurance policy, my payable upon death personal account. So my mother-in-law can come and just grab it all. And if you're asking why didn't I name my mom? Well, my mom is in heaven, so that's why I didn't. So choose somebody that you trust, designate that person, because you don't want to give more work and then now they have to open up a probate proceeding. I'm sorry, not a probate proceeding, a guardianship proceeding, which can actually be even more complicated. All right, let's see. Well, that's my presentation for now regarding probate. I hope I have answered all of your questions. If you have any other questions, please feel free to reach out to me. You can reach out to me via email. My contact information is romy@juradolawfirm.com. You can reach out to me via Instagram at romyjurado, ROMYJURADO. You can call my office, 305-921-0976. And, I try to be available and I try to be a resource for all the realtors. Okay, let's see. I think we're getting more questions. What is the average cost to set up a trust, attorney's fees, filing fees, etc.? If you guys send me an email, I will send you what we charge. The reason why I don't want to say it in video is because this is being recorded and I don't know if somebody's going to see this 5 years from now and then say that I'm falsely advertising because I'm charging more than. But if you're interested in fees, I will gladly share them with you. We do charge flat fees, so just send me an email and I will respond. The other one, with a PR, all expenses need to be authorized by the court. Example, replacement of roof, fixing something in the property. No, they do not. And that's the great thing about appointing a PR, that the personal representative can take action to basically protect the assets of the probate state. The only thing that I would say really need to get, you need to be approved is selling the property. But just the normal wear and tear, taking care of things, the PR can take a lot of actions to protect the assets of the state. Somebody's asking me if there is a replay. I am recording this. So if it comes out good, I will put it in my YouTube channel and I'll send everybody a follow-up email so that you have the link and you can follow it up and also the presentation. Let's see. Somebody's asking me, even when the beneficiaries aren't in agreement. So somebody can be appointed PR. But if the beneficiaries don't agree with what the PR is doing, they can actually file an action within the probate court to remove them as PR. So that's important. If the beneficiaries don't agree with what the PR is doing because you think they're wasting the probate state, you can file an action to remove the PR and then the judge will decide. So if that's the case, the PR can do that. All righty. Well, I want to wish everybody a fabulous week and a happy Cinco de Mayo. And I hope to see you all next. Thank you so much. Bye.